Hello everyone, my name is Andrea Harden and I'm the trainer coordinator for the Montana Human Rights Bureau, and I'm very pleased to be speaking with you today on the topic of pregnancy discrimination. The Human Rights Bureau, or HRB, is the state agency charged with enforcement of the Montana Human Rights Act and the Governmental Code of Fair Practice. Through a contract with the federal government, HRB also processes employment discrimination claims filed under Title VII of the Civil Rights Act of 1964, the Americans with Disabilities Act, and the Age Discrimination in Employment Act. HRB's main function is to conduct independent and neutral investigations into complaints of discrimination. The HRB also provides mediation services, which are completely free and voluntary and confidential for parties interested in engaging in mediation. Lastly, HRB offers education to the public, which includes employers, employees, students, tenants, housing providers, and any other interested party throughout the state. This is a preventative effort to further awareness of non-discrimination laws. So what is unlawful discrimination? Unlawful discrimination can be simply defined as an adverse action taken in a protected area against an individual because of his or her protected class status. So to help you more clearly understand the definition of unlawful discrimination, I'm going to break down some of the terms. This is a list of the protected areas under anti-discrimination laws that the Bureau enforces. You can see that it includes employment, public accommodations, governmental services, housing, education, insurance, and financial transactions. It is interesting to note that 85% of cases filed in fiscal year 2020 at the HRB were in the area of employment. In this slide, you'll see a list of all the protected classes under both federal and state laws. On the left side of the slide are the protected classes under the Montana Human Rights Act and the Governmental Code of Fair Practices. You will see age, sex, race, color, religion, creed, disability, national origin, marital status, political belief, and familial status. Under the side of federal laws, you have age, sex, race, color, religion, disability, and national origin. Note that Montana law recognizes the protected classes of creed, marital and familial status, and political belief, whereas federal law does not. The protected class of sex contains several subcategories, which was recently broadened by a Supreme Court decision this year that found sexual orientation and gender identity to be contained within the protected class of sex. As you can see, pregnancy is also included in this protected class, which we will now focus on a little deeper. In its simplest terms, pregnancy discrimination is treating a pregnant individual less favorably than a non-pregnant individual. In legal terms, we call this disparate treatment, which can manifest itself as unlawful discrimination in any of the protected areas covered earlier. However, in the area of employment, a pregnant person has certain rights as well. For example, a reasonable maternity leave. What is reasonable is not defined under the law, but is left up to the healthcare provider of the pregnant woman. It is not, however, determined by an arbitrary policy adopted by an employer. Using the state of Montana's policy as an example, it provides an employee with 6 weeks of maternity leave. However, if the employee needs more time for maternity leave, then she can provide her employer with medical verification of the additional need for leave. It is important to note that pregnancy is not considered a disability. Discrimination complaints related to pregnancy are filed with the Bureau under the protected class of sex. However, there are cases where pregnancy results in the individual having or developing a condition that also falls within the definition of disability. An example is an atypical pregnancy wherein a doctor requires the woman to be on bed rest or she has a severe case of morning sickness. If the pregnancy results in an impairment that substantially limits a major life activity, the pregnant woman falls within the protected class of disability as well as sex. If that is the case, as a person with a disability, she is entitled to reasonable accommodations for the disability. Turning now to the pregnancy discrimination laws, the Montana Human Rights Act has two specific provisions related to pregnancy in the area of employment. 49.2.310 Montana Code Annotated provides four prohibited actions of employers. First, an employer cannot terminate a woman's employment because she is pregnant. Second, an employer cannot refuse reasonable leave for the pregnancy. Third, an employer cannot require mandatory maternity leave for an unreasonable length of time. And fourth, an employer cannot deny an accumulation of pay or leave benefits as accrued by a pregnant employee if that employee is disabled as a result of the pregnancy. 49.2.311 Montana Code Annotated provides that an employee who takes a pregnancy-related leave of absence must be reinstated to her original job or an equivalent position with the same pay, benefits, and seniority once she expresses an intent to return to work. The administrative rules of Montana also provide several rules related to pregnancy discrimination. Many of them cite back to Montana Code Annotated and therefore may be a bit repetitive, but they are a great tool to look at to gain further insight on this topic. And last but not least, the federal laws that relate to what we have been discussing are the Americans with Disabilities Act, or ADA, if the pregnant individual develops a condition that qualifies as a disability, and Title VII of the Civil Rights Act for complaints of pregnancy discrimination under the protected class of sex. Montana's employers are often familiar with their obligations under the Federal Family Medical Leave Act, or FMLA, and may assume that because of the size of the company or the length of time an employee has worked for the company, that there is no obligation to provide her with maternity leave. However, that is incorrect. This slide shows a side-by-side comparison of our state law, the Montana Human Rights Act, or MHRA, and the federal law of FMLA on three different points. Please understand that the description of FMLA here is a bare bones basic description, and there are many other details to consider regarding FMLA coverage not listed here. But touching on these 3 points of comparison, under the FMLA, an employer has to provide maternity leave, but only if it's a covered employer, meaning that they have 50 or more employees. And further, an employee can only claim the benefit after she's worked at the company for a certain number of benefit hours. But the requirements of the FMLA are different than under our MHRA. All employers, regardless of the number of employees, are covered by our MHRA, and further, it doesn't matter how many hours the employee has worked when she requests the leave. Additionally, leave time under the MHRA is whatever is reasonable and is not set to a certain number of weeks like under FMLA. Taking pregnancy as an example of a medical condition to see how FMLA, the ADA, and the MHRA play out, under FMLA, if you're an employer with 50 or more employees and your employee has been there for more than 12 months, she may be entitled to up to 12 weeks of leave. Then, under the ADA, as we were just discussing, if the woman has an atypical pregnancy, an employer may have to provide reasonable accommodation to an employee or job applicant with a disability, unless doing so would cause significant difficulty or expense for the employer. And don't forget, leave can be an accommodation for disability as well. Then, under the MHRA, even if it's a typical pregnancy, and even if you're not an employer with 50 or more employees, and your employee just started yesterday, then the pregnant employee is entitled to a reasonable maternity leave. So to wrap it up and boil it all down to a few takeaway points, I'm going to go through some do's and don'ts regarding pregnant employees. First, the don'ts. An employer cannot refuse to hire a pregnant applicant based on her pregnancy. An employer cannot discipline or discharge a pregnant employee based on her pregnancy. An employer cannot force a pregnant employee to take an unreasonable leave of absence based on her pregnancy. Now for the do's. An employer must provide a reasonable maternity leave based on the recommendation of a medical provider. An employer must allow a pregnant employee to use accrued benefits and leave in the same manner afforded to non-pregnant employees. An employer must ensure pregnant employees receive equal treatment in employment benefit plans. So just a few final thoughts. Although pregnancy discrimination laws are a bit different in that they provide specific obligations and prohibited acts for employers, don't forget that disparate treatment of pregnant employees falls under the MHRA as well. For example, HRB does not enforce Montana's laws that cover public employers' obligation to provide accommodations to mothers that are nursing or expressing milk, but HRB does take and has had complaints where a female employee asserts her request for a break to express milk was denied while other employees were allowed to take breaks. It may also be of interest to you to know in closing that 100% of the pregnancy discrimination complaints filed at the HRB are in the area of employment and mainly in the service industry. Out of those filings, 43% allege termination of employment based on pregnancy. So with those final thoughts, I will thank you for taking some time out of your day to join me and learn a bit about pregnancy discrimination. If you are looking for additional resources on that topic and other discrimination-related issues, here's a list of resources for you to peruse. As always, don't hesitate to reach out to the Human Rights Bureau with additional questions.